Hello, my name is Michael Tesaro, and I prepared this video note on the recent High Court case of Stubbings and JAMS 2 Pty Ltd, which was an unconscionable conduct case. Bit of background about myself: I'm a competition and consumer lawyer. I've been running my own practice, Tesaro Legal Consulting, for the last 13 years. Prior to that, I worked with the ACCC for 15 years, and I had a range of roles there. One of my roles was as a Director of Enforcement, and I had cause to conduct investigations into allegations of unconscionable conduct. Now, the outline of the presentation is start with the facts and then look at the majority decision, which is by Kiefel, Keane and Gleeson. Then to have a look at the different takes on this case by Gordon and Stewart. Having said that, they all agreed on the ultimate outcome, which was that the conduct was unconscionable. Then I'll have a bit of commentary at the end. Now, the facts are that Stubbings had been seeking an asset-based loan, mainly because he'd been working in a business and also living on the premises, and he had a falling out with his employer, which resulted in him losing his job and his place of residence. So he had to find a new house to live. He had no job, no income, but he did own 2 houses, so I guess you'd say he was quite asset rich. He came across this individual called Mr. Zerkas, who described himself as a consultant, and effectively it was Mr. Zerkas who's suggesting to Mr. Stubbings that he look at an asset-based loan. And Mr. Zerkas is explaining the way it would work and also encouraging Stubbings to go down this path on the basis that it wouldn't be as problematic as Mr. Stubbings may have assumed it would be. Ultimately, Mr. Stubbings decided on purchasing a property in Fingal for $900,000, and at that stage, Stubbings was introduced to Mr. Zerolowski and AJ Lawyers. When I say introduced, they never actually met, and that's a very significant factor in this particular case, that Mr. Zerkas was very keen not to allow Stubbings to ever meet anybody from AJ Lawyers and Mr. Zerolowski, and that's relevant to the case later on. Now, once Mr. Stubbings had agreed on entering into this transaction, he required independent legal and financial advice. He had certificates from a lawyer and an accountant. And in this regard, it's interesting to note that AJ Lawyers recommended the independent legal and financial advisor, Mr. Stubbings, and it appeared that they had previous commercial relations with AJ Lawyers. So, the big question mark as to whether they were independent at all. Then, once that step had been completed, Mr. Stubbings entered into 2 mortgages. The first mortgage for over $1 million, and as you can see, very high interest rates, but particularly high default rates, which is very relevant here given that Mr. Stubbings had no job and no income. The second mortgage was effectively to cover all the costs associated with setting up the deal. So as you can see, very high default rates, 25%. So it was inevitable that Mr. Stubbings would default on his loan. He was able to make the first loan repayment, and then he was able to also make the second loan repayment of interest, I should say, by selling some personal assets. But when it came round to the third interest payment, Mr. Stubbings had no more money and defaulted on the loan, at which time the lender took proceedings to enforce their security. Now, at first instance, the case went to Justice Robson of the Victorian Supreme Court, who concluded that Stubbings was labouring under a special disadvantage, and that manifests itself as a lack of business acumen, a lack of sophistication, a failure to understand the risks associated with the transaction he'd entered into. The judge also described Mr. Stubbings' demeanour as being of childlike quality. Mr. Stubbings had actually been representing himself in the case and had shown a total lack of understanding and insight into the seriousness of the case he was involved in. So Robson concluded that Mr. Stubbings' financial position was bleak and that there'd been a high level of moral obloquy by the lenders. He also concluded that the lenders had been willfully blind to Stubbings' financial and personal circumstances. So they didn't want to know. They actively prevented themselves from knowing what his financial and personal circumstances were. He concluded that the loans were procured by unconscionable conduct, and he ordered that the mortgages be discharged and the loan agreement be declared unenforceable. The case then went on appeal to the Court of Appeal, and the most interesting finding that the Court of Appeal made was his critical view of the primary judge's views about asset-based lending, and they indicated that Justice Robson had effectively a biased view about asset-based lending, and this had overwhelmed his determination of the conscionability issue. In actual fact, they said that this negative view of asset-based lending had infected his judgment. It's quite negative of Justice Robson. And then the Court of Appeal decided that there wasn't unconscionable conduct because the lender was permitted to rely on the independent legal and accounting advice. So effectively, the Court of Appeal believed that the independent legal and accounting advice had been effective in explaining to Mr. Stubbings the risk of the transaction, so he entered into the transactions with full knowledge of those risks. So they reversed the primary judge's decision. The case then went to the High Court, and at that stage there's top representation on both sides of the case. Mr. Stubbings represented by Noel Hutley, whereas the respondents are being represented by Brett Walker. It's a pretty star-studded lineup. As you can see, the High Court majority consisted of Kiefel, Keane and Gleeson, and they approached the case very much on placing a lot of weight on what the primary judge had concluded, and that was that Mr. Stubbings was simply incapable of understanding the risks involved in the transaction. So they accepted that primary finding by Justice Robson. They're also critical of the steps taken by the lender to interpose this company as the borrower. So effectively, Mr. Stubbings had this company which he owned, but it wasn't trading, which was put as the actual borrower in the transaction. And the High Court noted that that was done for the purpose of preventing and impeding the scrutiny of the fairness of the transaction under the National Credit Code. So effectively, the code applies to personal domestic type loans, but doesn't apply to commercial loans. So by making the contract with Mr. Stubbings's corporation, then the code was avoided. It's totally artificial interposition of this company. And the High Court basically concluded that once one looks at the deployment of such artifices in this context, and the way that the lenders sought to deliberately distance themselves from knowledge of the borrower's special disadvantage, it's actually very strong evidence that their state of mind was aimed at exploiting Mr. Stubbings in this transaction. They also had a look at the unchallenged findings by the primary judge that Mr. Jarolowski had taken the opportunity of exploiting Mr. Stubbings' lack of business acumen and meagre financial resources. So this is a finding made by the primary judge with the benefit of seeing the witnesses, which you can't lightly set aside or ignore, which I think the inference is that that's what the Court of Appeal had done. Ultimately, they concluded that Mr. Jarolowski's conduct on behalf of the lenders amounted to unconscientious exploitation of Mr. Stubbings' special disadvantage, and the primary judge's decision had been correct. So they based their decision on the unconscionability in equity. They didn't see any need to look at statutory unconscionability. And that's where Gordon's decision differs from the majority. She would have found a breach of the statutory unconscionability provisions under the ASIC Act, namely Section 12 CB1. She comments on the way that the lender sought to avoid the operation of the National Credit Code by interposing Mr. Stubbings' company. She also noted the way that the lenders had a system in place of not negotiating with Mr. Stubbings, deliberately avoiding any knowledge of his personal financial circumstances on the belief that that would somehow prevent them from having their security undermined. And she actually concluded that it was a system which was designed to hide relevant information from the lenders so they would have no problem making the loan, pursuing the guarantee, or taking the security enforcement action. She also concluded there was a lack of transparency in the way they'd been dealing with Mr. Stubbings. That had been exacerbated by the certificates of independent advice, which did not appear to be very independent at all or very comprehensive in the advice provided. So she concluded that the lender's system of conduct was outside societal norms of acceptable behaviour and as such warranted condemnation as offensive to conscience. She also makes reference to Australian society's values and how this conduct was well outside or contradicting those values. So she concluded that in the circumstances, not only was there grounds for voiding the agreement's inequity, but there was also a breach of the statutory unconscionable conduct provisions in the ASIC Act. Stewart's approach was somewhat different. He focused quite a lot on the fees that were charged by the various parties involved in the transaction. He saw that there were very large amounts being charged, which had been described by the primary judge as being obscene. He also made reference to some of the findings of credit which Justice Robson had made about various witnesses, particularly Mr. Zukas, who described as not being an honest man. He'd given evidence in an arrogant, patronising way, and also that Mr. Gerolowski's evidence had been quite poor as well. So he goes back to a lot of those primary judge findings, which are very relevant in making any decisions on whether to overturn a decision. He also was referencing the deliberate steps that were taken to prevent discovery of any financial state of Mr. Stubbings' company. So in actual fact, if there'd been proper legal advice and economic advice, financial advice, those individuals would have looked at VBC and would have worked out whether the company was operating and whether it was generating income in order to service the loans. So that wasn't done, which also undermined the validity of those certificates. A further critical defect that he identified in relation to certificates related to the fact that whilst they were written with a view to VBC, there was actually no separate independent legal advice provided to Mr. Stubbings as a guarantor. So the absence of any reference to him being provided advice totally invalidated those certificates. So effectively, the case was decided on the basis of not statutory unconscionability, but on unconscionability and equity. One question that's really interesting is who is JAMS 2 Pty Ltd, and there's very little discussion of the actual lender in the case. There's no discussion of the relationship between the law firm AJ Lawyers and JAMS 2 Pty Ltd, which is, I think, quite unusual. Ordinarily, you'd be wanting to know who that company is and what the relationship is between the agents of JAMS 2 and JAMS 2 as the principal. And so I looked up this company, couldn't find it on the ASIC register. I actually think it's a discretionary trust, and it does appear that the owners of JAMS 2 are likely to be individuals involved in AJ Lawyers. I think it's any coincidence that you got AJ Lawyers and you got JA at the beginning of JAMS. So I think there was actually really no separation in practice between JAMS 2 as the lender and AJ Lawyers as the law firm. The interesting factor that Mr. Stubbings was actually forced to represent himself in first instance is surprising. He had a very meritorious case, and you would have expected he would have got some legal assistance. The other party that you may have expected to be involved in this case at some stage was ASIC. I would have anticipated that they may have decided to try and intervene at the High Court level to try to push the boundaries of statutory unconscionability under the ASIC Act, particularly after the unsatisfactory outcome in the Cobell case. The bigger issue this raises is whether there are major problems in asset-based lending. Is this company, AJ Lawyers, and the relevant lender an isolated example of bad conduct, or is this the way that companies are operating the space? Namely, are they seeking to interpose commercial entities in what are really domestic loans, personal loans, which should be subject to the credit code? Are they also seeking to maintain a distance from borrowers so they're not aware of any special disadvantage? So these are issues I think need to be investigated more thoroughly by ASIC, because the strong inference is that this might be a system which is being used by a number of companies in this space. I think finally this case does not really extend the law in relation to unconscionable conduct. It's relying on the equitable principle of unconscionable conduct. It doesn't make any new findings in relation to statutory unconscionability. But I think the main contribution this case makes is if a company seeks to willfully blind itself to facts such as the special disadvantage of a borrower or other features of an individual which may be relevant to enforcing a security, the courts are going to look behind that and take a more practical approach to sheeting home liability where people have willfully ignored and avoided relevant information. So that's all I had. I thought it was an interesting case, not groundbreaking in terms of the law which is established, but I think it does open up a can of worms in relation to asset-based lending and whether there are broader systemic issues there. Hope you've enjoyed that video. If there's any questions, feel free to give me a call or drop me an email. Bye-bye.